Welcome back to Federal and Indian Gaming Law. Today we're going to talk about intellectual property, and this is more of an overview. If you took the tech class, you had a much more in-depth dive into IP laws. Here we're just going to go and cover the four primary areas of IP protection, the four primary doctrines for IP. This is important because three of the four are primarily federal laws, and the fourth, while primarily state law, does have a federal law component that aids states in protecting their protected trade secrets in interstate and foreign commerce. So with that, we'll move on to talk about the doctrines. So you have patents, trademarks, copyrights, and trade secrets. And there's a little bit of overlap between some of these. There's some overlap between copyright and trademark. There's really no overlap between trademarks and patents. That's an error in the graphic. And there can be an overlap between copyrights and trade secrets. But let's start with patents. A patent is an invention, a discovery, or any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof. So a patent is it really applies to only things that are truly new and novel. And we'll get to that in just a second here. So to be patentable, first of all, you have to have patentable subject matter. Some things are not patentable, things naturally occurring in nature. It must have utility. It must have some kind of use case for it. It must be novel, meaning it can't be on sale or in commerce for a year or more. Can't be disclosed for a year or more commercially. Must not be obvious to one skilled in the art. So it can't be, a minor improvement on something that, heck, everybody knows that, or everybody should know that, that's skilled in that area. And ultimately, what is a patent? A patent is essentially a government-granted monopoly to the inventor to prevent others from making, using, offering for sale, or selling the invention in the United States, or importing the invention in the United States. And this is similar to laws in other countries. There's no such thing as an international patent or global patent. So patenting a new invention in the United States does not protect it in Macau, does not protect it in Singapore, does not protect it in Great Britain or elsewhere. Patent laws are national in nature. Ours is no different. But it is a very, very, very strong commercial right. It's not a commercial right to do something. It's a commercial right to prevent others from doing these things. And that's an important concept. With regard to prosecuting a patent, and again, the patent only exists once the federal government says it does. You can have a great invention, but if it's not patented, it might not be very protectable. So patents can only be prosecuted by the inventor, a licensed patent agent, or a licensed patent attorney. I am not a licensed patent attorney or a licensed patent agent. Therefore, I could not prosecute patents for others before the Patent and Trademark Office. Generally, the process begins with a patentability search and assessment. There's no point in spending money in trying to obtain a patent for something that's already been patented, or for something that is generally viewed as obvious to one skilled in the art, or to something that's been disclosed and is in the public domain. So you generally want to do these searches first. If the search comes back clear, now those searches, I should explain, if you're using a patent attorney to do a search for you, there are going to be a number of caveats in that letter. It's a difficult task to do a patentability search. And part of the reason is the language that's used in patents themselves. And that language changes over time. Just as there's colloquial English, which is different from legalese, there's patentese, which is different from both of those, where different words have different meanings. And the other thing is there are so many different patents out there now that the only way to really search is word search, and different words may be used for describing similar things. So the search is helpful. They're certainly not bulletproof, but I highly recommend doing that if you're working for an employer that has patentable inventions or has a new invention and wants to make sure that using it isn't going to get them in trouble because somebody else already has a patent on it. So assuming it's clear, you'll draft and file the application. You'll do that with the help of a patent attorney or patent agent. Generally, it's going to be a patent attorney. Once it's filed, the Patent and Trademark Office has examiners in each subject area. So, for example, if it's gaming devices or, a new handheld gaming device, they're going to have people that have electrical engineering backgrounds and some specialty in that area that will review the application, and they will object to it. Again, this is a very, very strong right. It's probably the strongest commercial right you could secure. It won't be easy to secure that right. And it's the job of the patent agents to make sure things don't make it through the process that shouldn't. So there will be objections called office actions. And then you'll have to work to overcome those objections, usually by providing a brief. Give you an example of this. When I was in law school, I clerked for a patent attorney. Some of her clients were large pharmaceutical companies. She had a pharmaceutical company that had come up with an invention for a microdosing patch. So you wear the patient would wear the patch. There'd be a certain amount of medication in it, and the patch itself would only dispense so much medication at periodic times, instead of just having a patch that goes on and having a transdermal constant flow of medication until the patch wears out. This would actually dose at intervals. And it did so using some microelectronics that ran off the current in your body, which is a very, very small current. So the patent application was filed, and it was rejected because of a patent that was issued in the 1940s or 50s for a shortwave radio that would run off the current of your body. Now, first of all, that patent, there's no way it could work. And the description was, if you could put these on airplanes. If an airplane crashed on a desert island, you could strap on the wristband. Your body would power the shortwave radio, and you could radio for help. It didn't work. It had nothing to do with transdermal drug delivery. But we had to write a brief explaining the differences and why this did not make the transdermal drug patch, a microdosing drug patch, obvious. So you will get these objections. You'll have to respond to the objections, usually with a brief. And the process of doing this usually takes more than a year. And depending on the subject matter area, it can take more than a year. It can take several years. And part of that has to do with the workload of the Patent and Trademark Office. And again, I mentioned those different offices. The equine office, equine inventions, probably in the late 1800s, super busy. Today, not so much. Computer-related, data-related patent applications, lots of them. That office is really busy. Pharmaceutical and drug-related patents, lots of those patent applications. Hard to get a lot of examiners for that. It's going to take a while. Again, the rights are strong, so the process of obtaining these rights is pretty rigorous and time-consuming. Standard duration for a patent is 20 years from filing. After the term of the invention, or after the term of the patent, the invention's in the public domain. So you only get a limited time to have that monopoly. And that's kind of the trade-off, is everything gets disclosed, becomes part of the public domain, but you get a 20-year exclusive to prevent others from making, using, selling, modifying, selling and importing that invention or releasing that invention in the US. But on the flip side, it becomes part of the public domain when it's done, and everybody can do that and everybody can build upon it. Internationally, the United States belongs to the Patent Cooperation Treaty, or the PCT. The PCT provides an avenue for applying for patents in other countries based on filings done in the United States. And by the way, this works both ways. So, if you're in the UK, they're PCT country, there are ways to file in the US based upon the filing in the UK, and the same goes for Canada and China and lots of places. We also are participants in other agreements, GATS and TRIPS, that provide other avenues for international patent protection. Again, it's a system to base patent applications in other jurisdictions based upon what was filed in your home jurisdiction. Again, talk to a patent attorney about obtaining patent protection in other countries that are important to your business, because this is not uniform. So just because somebody is part of or country is part of the PCT doesn't mean it uses the same process as everybody else in the PCT or other countries in the PCT. They have different time limits for filing, different methods for filing, different costs for filing. So definitely talk to a patent attorney. In gaming, generally, US is important, Canada is going to be important, UK may be important, certainly Macau, Singapore. So look at jurisdictions where your business is doing business, and if you've got a really great invention, protect it there. If you don't, so for example, you have a great invention for a new gaming device, and you get it patented here, the patent issues, and you fly to Macau and you see somebody else doing the same thing, there's nothing you can do about it. You don't have protection in Macau. You have protection in the United States, but not there. For them, it may be in the public domain because it's been published. So be careful with that. So what is patent infringement? Well, patent infringement occurs when you make, use, offer for sale, or sell the invention or import that invention to the United States without the permission of the patent owner. Doing any of the above with the equivalent of any claim is also infringement. And really important with patents, there's no such thing as innocent infringement. And independent invention is no defense. So your company comes up with a great new product. It was developed in-house. You get it on the market. You get a cease and desist letter from another patent holder who says, hey, this thing is identical to what I've got in my patent. Stop right now, and we're going to sue you for infringement, or we're going to settle. And you say, well, wait, we developed this in-house, but if it is covered by that other patent, it doesn't matter that you developed it in-house with no knowledge of the other invention. So this is a very, very, very strong right. So if you do have something that's patentable, file. What can damages be? Ooh. Injunctions, reasonable royalty, and lost profits. This is where patent lawsuits get into some astronomical numbers, particularly for technology that's never been licensed. Because at that point, the patent owner got a pretty strong case that they would never license it, and they'll go after everything they can. Seizure of imported goods by US Customs, not uncommon. And destruction of infringing matter. So if, for example, you have a new slot machine or new slot machine invention, and somebody decides to copy that invention and have it produced in the Pacific Rim somewhere where you don't have a patent, and they start importing it, you find out about it, you can actually have Customs seize that material and destroy it. So practice tips on patents. The infringement search is key, and it's key for a number of reasons. If it turns out that the search was not terribly effective or missed something, and your company goes forward and ends up violating somebody else's patent rights or infringing them, there are enhanced damages for willful infringement. So you don't want to be caught with willful infringement. And the infringement search and analysis can help in that area, if nothing else. The other thing is the patent process is, again, rigorous, which means expensive. And there's no point in engaging in that process if the invention you seek to protect is already in the public domain, or it's already the subject of a patent of somebody else. Again, when you develop new technology or a new method, do that search. The other thing is don't disclose it. And this is a problem, particularly for small inventors, because they'll have a great invention. I guess it's been at least 5 years now. I saw a client with an invention for a gaming table, an electronic gaming table that could quickly convert, from craps to blackjack to whatever. And it had a pretty unique display and display technology and surface technology to change like that. So instead of a felt, you did have a electronic display. The problem was they didn't have a lot of money. So they were out looking for investors to help before they filed their patent application. And my advice is don't do that. Get an application on file, because if you're shopping it around and that 1 year goes by, that 1 year on sale bar is an absolute killer. Even if the patent issues, it's going to be deemed invalid. So again, if you think you have a patentable invention or method, then seek patent counsel quickly. One other quick practice tip, and we'll get to this again, is there's no such thing as a provisional patent. And you'll hear this a lot when you're in practice. So-and-so's got a provisional patent, they filed it 2 years ago. A provisional patent is not a patent. A provisional is an application for a patent. But a provisional does not get examined. Provisional application is a placeholder for time. So what does that mean? It means if you file a provisional application, you have 1 year to file your utility application, or you are forever barred from filing a utility application for anything that's disclosed in the provisional application. So why do we have such things? Primarily because of universities. So research universities have professors write papers, professors give speeches, and often professors will not let legal know until the morning of the speech or the day before. So it gave universities a way to file something quickly to try and cover everything that professor was going to talk about or publish. And then it gave them a year to get the utility application together and filed. Although, again, when I was in law school, I did clerk for attorneys for WARF for a while. WARF is the Wisconsin Alumni Research Foundation. You can look that up. It's a huge patent holder for the University of Wisconsin. There were attorneys there that really didn't like doing the provisional, and if at all possible, they would file a utility application to cover things. In addition to utility patents, things that are useful, there are something called design patents. Not used a whole lot, although they're becoming used a lot more, I think, in the last year or two. And these are patents on ornamental designs. So it's not that the invention disclosed has utility, but it has an ornamental design. and the ornamental design itself isn't useful. And in some cases, this makes a whole lot of sense. The cost of prosecution is relatively low, and it does offer some limited protection. It's kind of a hybrid between trademark and copyright. We'll talk about those later. One area where you see this a lot are in car wheel designs. So I don't know if anybody's into cars, but if you are, you'll know that the wheel industry is huge. Not tires, wheels. Although tires use this form of patenting as well. And if you look at car wheels, most of them have at least 5 spokes. Why? Because the DOT requires that. So how creative can you get when you have the DOT requirements for wheel designs and strengths and things like that? Well, pretty creative. Now, is the design, if you do a design where, each spoke has a, cutout in it and it's, darkened or beveled in a certain way, probably not useful. I mean, it doesn't increase the strength of the wheel, it doesn't change the properties of the wheel, but it does make it look distinctive. And you see a lot of wheel manufacturers actually file design patents. I don't really see this too much with gaming. I guess in theory, it could be carpet designs and things like that, that would be unique and distinctive. But design patents do exist. Know they exist. If somebody comes to you and they have a design patent and it's for gaming, make sure you know what's actually being patented, what that patent covers, because design patents only cover ornamental designs, nothing functional. So, myths versus reality with patents. Patents are solely for machines? No. You have utility patents, which are useful inventions, often used for machines. There are plat patents. You're never going to see this in gaming. You might see this if you're in the cannabis industry, but you won't see this in gaming. And you have design patents, those ornamental designs. Another myth: everyone that invents something is entitled to patent protection for their inventions. No, absolutely not. The default rule in the United States is competition's good. If you don't patent your invention and somebody else does it, okay, that's competition. Patents only exist when the federal government issues the letters of patent. Just inventing something or coming up with something new doesn't actually provide you with any rights. We don't protect ideas unless they're patentable. We don't protect new inventions unless they're patentable and have actual patents issued. Myth: patents stop others from making an invention identified in the letters of patent. No, they're not self-enforcing. I get this question a lot. I invented this new video poker machine, and now I see it at the G2E show. They need to stop. I said, okay, then you need to hire us to engage in patent litigation. Well, I don't want to do that. That's expensive. Yes, it is. Patents aren't self-enforcing. The owners of the patent must actually bring infringement actions to prevent others from making, selling, offering for sale, or importing those inventions. So again, particularly small inventors, it's not the federal government that goes out and enforces. It's the patent owner that has to enforce. Another myth: patents give a right to make an invention. They don't. It's a negative right that you can use in court to prevent others from making, selling, offering, or importing that invention, or offering for sale that invention. Another myth: inventions must work to be patentable. No, this is a patent for a fire safety device. Now you'll note that the drawing has horses in the background. This is an old patent. And the idea was, with buildings now getting taller in the late 1800s, early 1900s, that fires were going to be a problem. And if you're at the top floors, you need a way to get down to ground level without going through the fire. And so this inventor came up with a set of wings you could strap to your arms, and you could fly or float right down to the ground. Anybody think this actually worked? Would you jump off of a 10-story building with a set of fabric wings on your arm? It doesn't work. The patent was issued, but it doesn't work. So you don't have to have a working invention to get a patent on it. That's not one of the requirements. And with that, we'll wrap up patents. Any questions? Have I put everybody to sleep? Oh, by the way, all the slides are up for the person that was asking about slides. The slides are online as we speak.
Professor, I went to I think it was Target to buy a rug, and there was patent pendant of the pattern pending, sorry. So why would someone do this?
Because what you're doing with patent pending and letting people know, that means the patent's actually been filed, or the application's been filed. Now, while that application is being examined by the patent office, and again, this can take years, you actually don't have any patent rights. The patent rights don't exist until the patent is issued, which means others can practice that invention. What you're doing by putting patent pending on a product is you're letting your competitors know, I've got a patent application in, and if this thing issues and you've copied me, I'm coming after you. So don't invest in copying this product because I'm coming after you if you do. Does that make sense?
Yes, thank you.
Yeah, you do see patent pending a lot. So we'll move right on to copyright. We talked about design patents being creative. Well, so are copyrights. They protect creative expressions in tangible media. So what I'm doing here, speaking, extemporaneous speech is not covered by copyright. However, it's being recorded. Because it's being recorded, that recording is protected because the recording is a tangible medium. Tangible medium can be computer code, computer files. It doesn't necessarily have to be tangible for people. It just has to be in some fixed medium. It protects the expression of it protects the expression of ideas, but not the ideas themselves. So anybody ever see a movie where there's like an abandoned kid and he turns out to have some special qualities, and he grows up sort of as an orphan, but maybe with a family member. And as he gets older, he becomes pretty well known and eventually locates his biological father, and then bests him in some confrontation. I could describe a lot of different movies. There was a time when was it Meg Ryan and Tom Hanks were in the same movie like 5 times, just had different names. So the idea of that plot line is not protectable by copyright, but the expression is. So copyright only protects the expression. It protects creative elements of a work, but not any functional or utilitarian elements. A good example of this is there was a sculpture done by somebody, I think it was in the early 70s, and the sculpture was a tube that went up, over, down, up, so it's kind of like a squiggly line embedded in the ground. And later on, somebody figured, you know what, that'd make a great bike rack. And so they came out with a bike rack that looked just like it. And the court said, no, you can't separate the creative element, that artistic element in this, from its function. no copyright protection as it's used for a bike rack. Again, it can protect things like web page content, graphics, animation, sound, source code. It can protect manuals, employee handbooks. Lots of things in business can be protected by copyright. It can protect system documentation. Unlike patents, rights vest immediately. As soon as the work is reduced to a fixed or tangible medium, the rights exist. Registration is not required, but it's helpful later on if you have engaged in an enforcement action. So who owns copyrights? Well, the author owns the copyright. The origin of copyright law comes from the UK. And the issue that was occurring there in the 1400s was that publishers seemed to own everything, which stifled the creation of creative works. And the thought was to protect artists from publishers and others so that more creative work would be made. And therefore the author is the owner of the copyright. And the author is the person that puts the expression into a tangible medium. In a true employment situation, the employer may be deemed the author if the work was done within the scope of employment. And that's key. It has to be done within the scope of employment. So you have a janitor that comes up with a really cool craps table felt design, brings it to management. Management loves it. They put it on the floor. Who owns that design? Probably the janitor. Generally not within the scope of being a janitor to create felts for craps tables, right? Independent contractors will retain ownership of a work absent a written agreement to the contrary, and it has to be very specific. So you're a casino company, you commission a third party to create an ad campaign for you, and the ad campaign is really successful, and you start making changes to it, and you get a cease and desist letter from the original creator of that campaign, you know, the materials. They probably own it unless you have an agreement with them that says otherwise. You can have an agreement with them that says you're going to create the campaign for me, I'm going to own the campaign, but you won't own the creative works in it unless the agreement specifically says so. So this is a bit antithetical to everything else. Usually if I pay for it, it's mine. Here, if you pay for it, doesn't mean it's yours. With respect to the work itself, the copyright owner or the author has the exclusive right to reproduce and make copies, create adaptations, enhancements, and changes, new versions, distribute the work publicly, and perform or display the work publicly. That second bullet point there, or sub-bullet point, creating adaptations, leads us to a myth, which we'll hit again, but, and I just ran into this with a client. They had an employee copy something from the internet, make some modifications to it, and they got a cease and desist letter. And their view was, hey, I made it 90%, you know, only 10% of that's, you know, from the original image I copied off the internet. 90% of it's my work. It doesn't matter. The fact that you changed it at all means it's an infringement. Notice can remove an innocent infringement defense. There is an innocent infringement defense to copyright infringement. So what does a notice look like? Kind of like this. I like to use 2020 because 2020 is hindsight. But the circle C, the year, copyright owner, or copyright, the year, the copyright owner, or COPR period, the year, the copyright owner. And this has to be positioned in a place to give reasonably effective notice. Lack of proper notice may result in a disallowance of damages in a successful infringement suit. So again, no notice. You're not gonna know. Registration is done through the Copyright Office of the Library of Congress. Registration forms are available via the Library of Congress website. Registrations must be filed prior to bringing suit. So you don't need a registration to own rights, but you do need a registration to bring a lawsuit. And if you don't register within a 3-month period of the initial publication of the work, you might not get things like statutory damages and attorney's fees unless the registration is made within 3 months of the initial publication. Lost profits, disgorgement of profits, statutory damages, attorney's fees, impoundment, injunction, destruction of infringing materials are all on the table for damages in an infringement suit. For infringement, anyone that makes a copy, creates an adaptation, makes an enhancement, makes changes, creates new versions of the work, or publicly distributes the work, can be held liable for infringement. You need the owner's permission to do those things. Duration, maybe forever. No. Duration keeps getting pushed back every time Steamboat Willie for the Disney Corporation comes up for expiration of its copyright, or the Rhapsody in Blue music comes up for expiration under its copyright. The Gershwin estate makes a fair amount of money off of Rhapsody in Blue, and of course Disney makes a lot from Mickey Mouse. So for works made for hire by natural persons, it's the author's life. Or I'm sorry, for works authored by natural persons, it's your life plus 70 years. Life of the author plus 70. For works made for hire, it's 95 from publication or 20 years from creation, whichever occurs first. For other types of works, consult the patent attorney for, there are lots of different ways. You can publish under a pseudonym, that gets a different duration. Works created before 1978 that were then later protected get a different duration of protection. But see Copyright Counsel or start reading the statute. Practice tips, make sure you own what you think you own. When I started practicing, websites were relatively new for casino operators, and especially for small casinos. A lot of times they'd have, well, you know, Bob in finance, his nephew does websites. He can create one for us. We'll pay him 50 grand. And they do. And then they start making changes to it, and they get a cease and desist from Bob's nephew's attorney saying, hey, we own this. You can't change it without our permission. And we would like to be the ones changing it for you. So you either hire us to do it or you create something completely new. And they were right, because there was no agreement assigning that copyright. Even though you got paid 50 grand to create it, still owns it. So definitely have definitive agreements. Define the scope of employees. So for works made for hire, have agreements with independent contractors. It's probably the most prevalent type of IP you see on the web. It's copyright. Again, another myth is just because you're changing it doesn't mean it's yours. Take away the rights of the original author, and in fact, de facto infringement right off the bat. There is something called fair use, but in a commercial sense, almost never exists. Questions about copyright? Uh-oh. Can everybody still hear me?
Yes.
Yeah, we can hear you.
Yes.
Okay, great. I just received an internet is unstable message from Zoom. And I'm wired, so I'm not on wireless. I'm not Wi-Fi. I'm on Ethernet. So that's a bit concerning. Questions on copyright? Well, let's move on to trademark. Anybody know what that symbol is for? What it represents?
Nike.
Nike. What does Nike do?
Their
It's a
shoe co-
clothing brand.
They're a shoe company.
Shoe company, clothing brand, sports equipment. Yep. You see this, what do you think of?
Soda.
Diabetes.
Diabetes, soda, perfect. The ultimate driving machine. Anybody know what company uses that?
BMW.
Yeah, BMW. Hopefully this will work. Ready? It's a little tougher over Zoom, but hopefully you can hear this. Ready? Did you hear that? Did you hear the sound or no?
Yeah, we could hear it.
Okay. Anybody know what that sound is for?
I put in the chat, I think it's NBC.
NBC.
It is NBC. All these things are trademarks. So what does a trademark do? It's kind of like brand identity or identity law in a commercial setting. So it's any word, name, symbol, or device, or any combination thereof that can distinguish one provider's goods or services from that of another. So you saw the swoosh, you thought Nike. You saw the Coca-Cola script, you thought the Coca-Cola company and their products. It's that association made in the minds of consumers. Product configurations, you know, that Coke bottle shape is pretty iconic. It's distinctive. And that's the key with trademarks. They have to be distinctive for their use. So this is what we call the trademark continuum of strength. So trademarks are inversely protectable or protectable in a manner that's inverse to their ability to tell you what the product is. So things that are really strong. Rolex for a watch. What does Rolex mean outside of being a watch? Has no meaning. Same with Exxon, Kodak. Those are really, really, really strong because there's no need to use those phrases unless you're talking about that company or that company's products. Those are just made up words. Then we move down the continuum of strength to arbitrary uses of words. Apple for computers. What do apples have to do with computers? Anything? No, they don't. I mean, it's just an arbitrary use of the word apple. What about apple for fruit? Not going to be protectable because that's exactly, you're just telling people what the product is. Ivory for soap, camel for cigarettes. And again, arbitrary uses of words are pretty strong. I mean, Apple for computer is really strong because there's no need to use the term Apple or a like term for computing products unless you're trying to associate yourself with Apple or create some kind of association or endorsement or sponging off the goodwill that Apple has created with their computing products. Moving down the line a bit farther, you have suggestive marks. These marks are also protective initially because they don't tell you what the product is. They don't tell you what's in the product. They don't describe a quality of the product, but they sure suggest it. You know, Swatch was deemed to be suggestive for Swiss-made watches. Playboy for magazines, because it kind of suggests the lifestyle that the magazine was trying to portray. And Q-tips, you know, so for cotton swabs. on a stick. Moving down farther, you get descriptive marks. Now, descriptive marks are not protectable unless through time and use, the consuming public has come to associate that mark with a particular provider's goods or services. So McDonald's, a good example of this. When the first McDonald's restaurants opened up in California, California by the McDonald brothers, and they only had one restaurant in California. If you were living in Illinois, could you open up a McDonald's restaurant if your name was Bob McDonald? Yeah, you could. Because what in that context, what is McDonald's doing? Well, it's telling you who owns the restaurant. It's the quality of that restaurant. Today, can you do that? I'm Bob McDonald. I live in Las Vegas, and I'm going to open up a hamburger stand, call it McDonald's. Anybody think you can do that without getting a nasty gram from the McDonald's Corporation?
Likely not.
No, they're going to come down hard on you. Why? Because, with what, 60, 70 years of use and lots of advertising dollars, McDonald's now is synonymous with a single provider. American Airlines, another one. When it first was used for the airline that we know of as American Airlines, not protectable. Anybody could have said, I could have said, we're going to call our airline Bonanza, an American airline. There's nothing they can do about it. They probably still can't. But it describes what, qualities of that, of the underlying services. It's an airline and it's American. But through decades and decades of use in advertising, it has acquired something called secondary meaning. And secondary meaning then makes it protectable. So descriptive marks are not initially protectable, but they can become protectable once the consuming public has that secondary meaning associated with that mark. And then you have the weak or generic marks. These are totally not protectable. Casino for casino services, not a protectable term. Everybody in the casino industry can use the term casino to describe what they're doing. And American airline, not protectable if it's an airline from America. Good example of this. Anybody familiar with Howard Hughes? No? Real wealthy guy, made a lot of money in oil, owned an airline called TWA, Trans World Airline, which is, I think it was bought by American Airlines about 15, 20 years ago. Anyway, Howard Hughes, pretty big personality, had a rival, a guy named Juan Trippe. Anybody know who Juan Trippe was? No? Anybody ever hear of Pan Am Airlines? Another now defunct airline. Anyway, Juan Trippe ran Pan Am Airlines. He was an Ivy Leaguer, was great at raising money. And Pan Am and TWA were staunch competitors. And so when Pan American Airways finally had a route that would take you all around the world, not lots of stops, but you could do it, they started advertising an advertising campaign that said, Pan American Airlines, the only trans-world airline. And that just got under Howard Hughes' skin to no end. And these guys were personal rivals. So, but why could Juan Trippe do that with Pan Am? Because he was telling the truth. And trans-world airline was not a very strong mark. It's a weak mark, descriptive at best. So again, protection is only available for things that are distinctive. That will change depending on what the underlying goods and services are. So again, Apple for computers, distinctive. No need for a competitor to use Apple in or for computing products unless they're trying to sponge off the goodwill of Apple. But that same term used for fruit, not protectable at all. You know, if you're an orchard owner in Washington State, you can market your fruit as apples if they are indeed apples. And every other grove owner can do the same. Generic terms aren't distinctive and they can't become distinctive. Descriptive terms can once they have secondary meaning. And terms that were once protectable can cease being protectable if the owner of the mark doesn't make efforts to prevent that from happening. And we'll talk about that in a little bit too. So how do you obtain rights? Use. Again, it's marketplace identity. Hard to have marketplace identity if you don't use the mark. Common law rights begin when the mark is used in commerce in a particular geographic area. In states, you can file a state registration, which should protect you within that state, but you're gonna have to show use first. Federal registration is the most popular protection method for trademarks. And basically you get that once you start using your mark in interstate commerce and you've filed and acquired a federal trademark registration. Now, with state registrations, you generally can't file those before use is started in the state. With a federal registration, you can file an application on an intent to use basis before you use it, but rights will never mature until you actually use the mark. So use, what kind of use? Well, it has to be the kind of use, you know, the market that you're serving could identify the product based upon the mark. So depending on the product, a trade show use might not be enough. The use has to be sufficient for the public to identify the mark and distinguish those services or goods from those of others based on the mark itself. A trade name or a corporate name might also be a trademark, but it might also not be. Anybody know who Doctors Incorporated is? That's a corporate name. Anybody know what their trademark is for quick serve restaurant services? Subway. Again, those are the types of use you need. Common law, you know, wherever the geographic area is. State requires use in the state. Federal, interstate commerce. So process, first thing you want to do is an initial search. At a very minimum, you want to check the federal database to make sure that your new mark isn't being used by somebody else. Why? Because your use may end up becoming an infringement and you don't want to start using a mark that's going to draw an infringement suit. Federal trademark database is free. It's easy to search and you really should do that. And the registration is deemed to be de facto legal notice of somebody else's rights in the mark. So even if you don't know, it doesn't matter. Again, because rights can begin with use at common law or in a state with state registration, you may want to do a full search. And a full search uses proprietary databases to check common law uses, state registrations, as well as federal registered marks and federal applied for marks. Full searches using those proprietary databases probably going to cost you roughly $1,000 for the report. Somewhere between $1,000 and $1,500 probably. If everything looks clear, you can prepare and file an application. If it's federal, you're going to interact with the United States Patent and Trademark Office. So, assuming you get a federal trademark registration, what does that give you? It gives you a presumption, a legal presumption of an exclusive right to use that mark for the goods or services disclosed in the mark registration. And I guess this is something else we should talk about real quick. You can have multiple companies have the same mark. as long as it's not a confusingly similar use. Anybody remember the Riviera Casino? Nobody? There once was a casino on the Las Vegas Strip called the Riviera. You'll see it in a lot of movies and things like that. And Riviera Casino Corporation owned the trademark for that for casino services. General Motors has a trademark registration for Riviera for automobiles. There was a Buick Riviera for years, and every couple of years they do a Riviera version of one of their other cars. There is a ceiling fan company that makes ceiling fans under the Riviera mark. There is a window blind company that uses the Riviera mark for window blinds. And how can these all exist and all have federal registrations? Because the use case is different, and it's different enough where there's no likelihood of confusion. And we'll talk about that in a bit. Once you have a registration, you have the ability for some enhanced damages, and you have presumed nationwide notice. So for federal registrations, what's the maintenance? Well, you have to file an affidavit of continued use between the 5th and 6th year, and then every 10 years after that, and you have to file renewals every 10 years. If you don't, the registration will go away, but your rights, at least at common law, won't. If Coca-Cola decided, you know what, we're tired of paying the federal government, we're going to let our mark registrations lapse, Coca-Cola would still have strong trademark rights. They just have to prove it. They wouldn't have the legal presumption. So losing the registration does not mean you lose all your rights. At state level, it depends on the state, but usually have periodic renewals. Most states are 5 or 10 years. And for all registrations and all trademark use, you really do need to police the use to make sure you still have source indicating qualities for the mark. We'll talk about that in just a bit too. Marking, circle R, but only for registered marks, federally registered, not for state registered, not for common law. For common law and state, you can put TM or SM to the right of the mark. The only time, you just don't see SM very often. There was a time when a clothing company with a risque name actually had a federal registration, but they decided to use the SM, a little SM above and to the right of their mark, I think for enhanced marketing. So, but you don't usually see SM, you see TM, but not SM. You see R a lot, but only if it's federally registered. If you don't use that and you have a federal registration, it can limit your damages. If you don't have a federal registration and you use it, it could be trademark misuse. So don't want to do that. And you can never get a registration. How long do trademark rights last? Well, patents are 20 from filing. Copyrights, author's life plus 70. Trademarks, potentially perpetual, as long as that source identifying quality is maintained. And just because Coca-Cola has been in business for 100 plus years doesn't mean the rights in their mark go away. Their marketplace identity is still their marketplace identity. For registrations, you do have to do you have to maintain those registrations with periodic filings. You can lose rights. And I have to thank the Xerox Corporation for providing me with these graphics. And it's used with permission from Xerox. They're really nice about it. And this is one of their ads. And it says, once a trademark, not always a trademark. And I think this goes in-house, but trampoline was once a trademark. Kerosene was a trademark. Cellophane was a trademark. Not anymore, because the owners of those marks didn't police the marks, and the product that it was used on originally, it has basically been renamed by consumers to being that trademark. And Xerox has a problem with this. And how many times have you heard somebody say, oh, can you Xerox this for me? And the answer is no. And they really do try. Not even Xerox can Xerox. Xerox is a trademark for copiers, automated copiers. It's not a verb. And they place these advertisements periodically to try and preserve the source indicating qualities of their mark. And again, Xerox is a coined term. It's extremely protectable, but they do have to go out and protect it. If you ever represent a newspaper, you will get emails or letters from Xerox. You will get letters or emails from Kleenex. You will get letters and emails from Rolodex. If there's a news story, for example, police raided an illegal gambling house and impounded computers and a Rolodex or a set of Rolodexes. The Rolodex company will send a letter to the newspaper and their counsel saying, please use the term rotary index file. Rolodex is a trademark of the Rolex Group or our Rolodex company. And unless it was actually our brand of product, please don't use our brand as a generic term. So you can lose rights. Google is probably in danger of this at this point. Infringement is based on likelihood of confusion. I've used that phrase a few times. But likelihood of confusion means that consumers could be confused as to the source, affiliation, or endorsement of goods or services. So how do you assess that? Well, you look at the strength of the mark and whether it's protectable. Strong marks are entitled to enhanced protection, weak marks are not. The degree of similarity between the marks, the similarity of the products and services offered. Again, Riviera, identical mark, fairly strong for how it's being used, but the products were different. Cars were, nobody's getting confused. Oh man, I thought I was making a reservation at the Riviera Hotel Casino and I ended up with a car. It's not reasonable. Evidence of actual confusion is not dispositive, but it can help. Similarity of marketing channels, sophistication of the buyers, defendant's intent in adopting the mark, and the likelihood of expansion of the product line. And this is, that likelihood of expansion or that natural zone of expansion varies from mark owner to mark owner. I mean, with Nike, somebody said clothing, somebody said shoes, athletic goods. Nike did get into golf for a while, said golf products. If you came out with a line of chairs and keyboards for esports and decided to use the Nike swoosh, do you think you get a letter from Nike? I think so. I think it's probably within their natural zone of expansion from real sports to esports. So, but it depends. Damages, lost profits, infringers' profits, disgorgement of profits, statutory damages, attorney's fees, injunctions, destruction of infringing articles. You see this a lot with clothing items like Burberry purses that are knockoffs, things like that. Those will be impounded and destroyed. Practice tips: start with a strong and protectable mark. Your clients don't want to do that usually. Usually they want to tell everybody what their product is, and then they want to protect that descriptive protection. It's not going to work. Other practice tips: don't use other people's marks, particularly online in your site, your website, your apps, in URLs and path names. It's trademark misuse. Don't do that. Preserve the source indicating quality of your marks if they get so valuable that are known for the product that it becomes the name of the product. If you're working for a company, you're in-house, or even if you're not in-house and you're outside counsel to a gaming company, and they've got a new mark that they're floating for either a casino or an area of a casino or a restaurant or something like that, and the domain name is available, the .com, and they're looking at like 10 different marks, go grab all 10 domain names if you can. Nothing wrong with that. If you don't use it, just let it expire. But that registration is only 20 bucks. And while you can have lots of users of a particular mark, again, Riviera for a casino versus a car versus window blinds versus ceiling fans, there's only one Riviera.com. And I think it's owned by an accounting company, of all things. So domain names are unique. Go grab it if you can. It's cheap. And you can warehouse them. It doesn't matter. Questions about trademarks? Wow, I'm either putting you to sleep or I'm really, really good. I'm guessing it's the former rather than the latter. Trade secrets. Primarily state law based, but there is something called the Federal Defense of Trade Secrets Act, which can enhance state law trade secret violations into federal offenses. So what is a trade secret? And this is pretty uniform in most states. It's information, including a formula, pattern, compilation, program, device, method, technique, basically information that is economically valuable, at least in part due to it not being generally publicly known, and it's the subject of efforts to keep the information secret under the circumstances. So what do? Keep it secret. Remember a client that came in that wanted to sue a competitor that had hired one of their employees because they were now making sandwiches with the same ingredients as this employer. These were sub sandwiches or cold cut sandwiches. And the problem was they had everything online. They told you exactly what was in each sandwich. That's not secret. So use reasonable efforts to prevent disclosure. Use non-disclosure agreements. These can be helpful for patent as well with that on-sale bar. Educate employees. Have written employment agreements with employees regarding trade secrets. And when employees leave, have exit interviews reminding them that, hey, you learn trade secrets here, you can't use them elsewhere. Same thing goes when you're hiring, though. When you're hiring, find out if your employee has any trade secrets they're not supposed to disclose. In the casino industry, we see this a lot with slot hosts and casino hosts because they'll have a stable of players. The ones they've developed, fine, they can take that information, but what they can't do is they can't take the information about that the other hosts have and start contacting those other hosts' players once they leave the company. And with thumb drives, this is a huge issue because what will happen is somebody will just download the entire player database, move to another employer, and start working that database to try and bring them over. That's a big problem. Gaming will get involved in addition to potentially having a lawsuit on your hands. Another issue is don't hire employees to perform jobs that will require them inevitably to disclose or rely on the trade secrets of their former employer. Good example of this was a pizza company, California. And a guy they hired and trained to make sausage for sausage pizzas. He gets hired by a competitor, and the competitor puts him in as the head of sausage making for their pizza company. Now, he knows one recipe and one recipe only. It is a trade secret of his former employer. His new employer was sued by the former employer, and they were enjoined. Why? You can hire him to do things at a competing company, but you can't put him in a position where it's likely that he's going to rely on the trade secrets he learned at his prior employer. You want to put him in at the head of delivery. You want to put him in charge of purchases, fine, but not making him the head sausage maker because he's And he's got one trick, he's got one recipe, and that was a problem. Don't engage in questionable methods to obtain information. Don't ask questions in hiring interviews that you know are likely to be trade secrets of your competitors. It's a bad idea. Damages really depend on the state. At the federal level, it can be treble damages, so just be careful. Treat information as you would if it was a valuable and tangible asset. If you have trade secrets, or your employer has trade secrets, or your client has trade secrets, educating employees is key. Don't put employees in situations that are going to cause them to disclose. And we'll skip demand letters for now, because we are pretty close to the end and I want to leave some time for questions. So again, copyrights protect expressions of ideas, not the ideas themselves, and they're owned by authors. So be careful with the ownership. Key in the gaming industry is making sure that you have agreements with independent contractors. This comes up more often than I can tell you, where somebody at a casino will hire somebody else to create either ad content or felts or signage, whatever. You need to have an agreement that says you own it. Trademarks protect sort of that source affiliation, you know, that mind association that consumers have between the mark and a particular provider's services of those marks or goods. And you have to preserve and police the market to preserve ownership rights in your mark. Patents are government issued monopolies. They only exist when the patent issues. No protection for ideas. Really doesn't exist. Competition's good is sort of the mantra here in the United States. Just because you invent something doesn't mean you have rights in it, or the right to prevent others from doing it, unless you have a patent. Trade secrets, only valuable if it's kept secret, one key. And from a business perspective, don't hire people that have trade secret obligations to perform roles. Well, they'll have to rely on that trade secret information of another employer or a prior employer to do their job. You're going to end up in trouble. So with that, questions? Any questions? Oh, got some chat. Sorry. Back to the NBC thing. No questions. I've put everybody to sleep. We're going to do AML Monday. AML has been now rescheduled. I just got a text from the guest speaker. So let's move something else into that. Let's do fantasy sports for Monday. All right. Still working on the sports guest speaker. He's had to reschedule as well, but we'll do that. It's the challenge with guest speakers is everybody's busy, particularly right now, and making sure people can clear their schedule for it. Anti-money laundering will be on the 25th. So second to last class. The last class on the 26th will be a review. We'll start talking about the exam probably on Monday. What can I tell you? The slides, let's switch the share here. All right. Slides should be up. Let's make sure they are. Yeah. up for everything except for today. And the videos online should be caught up pretty soon. And with that, I have nothing more. So